I did not have that opportunity.
Me too.
Yeah. All right, so we'll go ahead and get started now. Thank you all for joining us. We are talking today about the Supreme Court's gun docket and the cases, both the one that it's granted recently on the Second Amendment. I'll talk a little bit about that, but also what other Second Amendment cases are in the pipeline. So we have two great distinguished local guests for us today. I'll introduce them. I'll give a little framing of the one case that we're going to talk about a little bit that the Supreme Court heard in December, and then I'll turn it over to the panelists, and we'll have a time at the end for Q&A, so if you have any questions, just jot them down and make sure that you remember that we're going to have that time at the end. So first we have Professor April Dawson. She, like me, is a California native. She received her undergraduate degree in computer science from Bennett College and her law degree cum laude from Howard University School of Law. While at Howard, she was an editorial board member of the Howard Law Journal and a member of the National Moot Court team. After law school, Professor Dawson joined the Civil Division of the Department of Justice through its Attorney General's Honors Program. She served as a law clerk to the Honorable Emmett Sullivan of the U.S. District Court for the District of Columbia, and she joined NC Central School of Law as a full-time faculty member in 2006, where she currently teaches in the area of constitutional law, Supreme Court practice, and torts. She's been voted Teacher of the Year by both the day and evening students. She also co-hosts the Legal Eagle Review radio show, which airs every Sunday evening on WNCU 98.7, and it's available on iTunes. And I'm a big fan of podcasts, so I'm going to catch this. Next to her, we have Professor Greg Wallace, who teaches constitutional law with an emphasis on free speech, church and state, right to arms, and constitutional interpretation at Campbell School of Law. He received his LLM and SJD degrees from the University of Virginia School of Law. His doctoral dissertation was entitled Higher Call, Foundations of Religious Freedom in American Constitutionalism. He received his JD with high honors from the University of Arkansas Little Rock, where he graduated first in his class, was editor-in-chief of the Law Review, and won a national moot court competition. He also obtained an MA degree with honors from Dallas Theological Seminary. Before joining the Campbell Law faculty, Professor Wallace served as a law clerk to U.S. District Court Judge Susan Weber Wright and was a visiting professor at the University of Arkansas Little Rock. He received the Dean's Award for Faculty Excellence in Research in 2004 and has argued more than 150 cases in federal appellate courts in the 4th, 5th, 6th, 7th, and 8th circuits. So thank you both for being here. So one of the cases that we're going to talk about today, and it'll probably take a little bit more of our time than the new cases, is a case called New York State Rifle and Pistol Association against the City of New York. This is a Second Amendment challenge that was argued this past December, and it was the first time the Supreme Court has heard oral arguments in a Second Amendment case since 2010 in the McDonald case, which is the follow-on to Heller. Really, Heller and McDonald are the only two other times the Supreme Court has addressed the Second Amendment in any kind of authoritative way. So this was shaping up to be a big deal in 2019 until a few things happened after the Supreme Court granted cert. So after the Supreme Court granted cert in this case, New York City repealed the law that was being challenged, and New York State came in and preempted local regulation that would basically do what the challengers didn't want it to do. So there was this big debate when we got to oral argument whether the case was moot anymore. Did it present a live controversy still? So we'll talk a little bit about that, the mootness and how that interacts with the merits. But the merits of the argument were that there was this New York City regulation that prohibited individuals who held a premises license, a license to have a gun in their home in New York City, from taking that gun to shooting ranges outside of New York City or to second homes. And the plaintiffs challenged that law on Second Amendment grounds and said it violates our rights under the Second Amendment to keep and bear arms, to not let us take that to, say, a second home in upstate New York, or to take it to a shooting range in New Jersey or anywhere else outside the state. The lower court, the district court, upheld the law against these challenges. The Second Circuit panel unanimously upheld these laws against a challenge. And then it came to the Supreme Court, and the Supreme Court again granted cert on this question. And then there was the changes in law during last summer that made it different from the case the court had granted. So we'll talk a little bit about what that mootness means for what the court might do with this case, and whether the justice's view of the mootness question, of the justiciability question, was influenced by concerns over whether or not municipalities and state governments and other courts were respecting the right to keep and bear arms in the way they should. So before we get to some of those questions, or maybe they'll address some of these questions, I'll turn it over to our panelists to talk a little bit about their views on this case. NYSERPA is what we call it, and then also on some court culture, court composition, and some maybe things to look down the pipeline on gun cases.
Okay, all right.
So first, Jake, thank you very much for inviting me, and thank you all for coming to this discussion. I hear there's a competing panel, so I'm glad you all are here. So in thinking about this particular case, I study the Supreme Court. I teach a Supreme Court seminar, and regardless of my view on the merits of a case, I typically will think about it from the context or through the lens of the Supreme Court as an institution. And so my remarks and comments are going to kind of come from that perspective. Jake mentioned that this is the first time that the Supreme Court has taken a Second Amendment case where it has a potential of really deciding the issue of the means by which it decides these Second Amendment cases. But that wasn't for a lack of opportunity. So there are 4 cases that I want to just kind of highlight real quickly. And these were cases where the Supreme Court denied cert. And in denying cert, Justice Thomas actually filed a dissent attached to the denial of cert in those cases. And so there are 3 cases that came out of the Ninth Circuit, 1 that came out of the Seventh Circuit. And so the first case out of the Ninth Circuit was 2014. This was the Jackson case, and this case focused on a San Francisco ordinance that said that in keeping a handgun in your home, it had to be either locked or carried on the person. The court denied cert in that case in 2015. Then there was the Seventh Circuit case out of Illinois, which was a case challenging an assault weapon and magazine ban. In the case, the Ninth Circuit case, 2014, Thomas dissented. That dissent was joined by Justice Scalia. The Seventh Circuit case, again, the Supreme Court denied, and Thomas dissented, and that was joined by Justice Scalia. And then the Peruta case, again, out of California, the Ninth Circuit, and that was a challenge to the good cause gun carry permits. And that was a case where Thomas again dissented, and his dissent was joined by Justice Gorsuch. And so this was after Scalia's passing, and Justice Gorsuch filled his seat. And then the Sylvester case, this was a Ninth Circuit case, 2016, dissent by Thomas. It wasn't joined by any other justice, and this was a challenge to the California 10-day waiting ban. Now, the thing about decisions on whether to grant cert. So we don't often know why it is that the court denies cert. And even though if you've got a 9-justice court deciding a case, you need at least 5 justices. In order for the court to hear the case, you only need 4. And so when we look at these particular cases where the court denied cert and Justice Thomas filed a dissent, he felt strongly enough about the denial of cert that he wanted to write a dissent. And so if you think about the Supreme Court is having to decide roughly 8,000 cert petitions. The court grants only between 80 to 100. And so the vast majority of denial of cert, there is no dissenting or concurring opinion that comes from it. So it's not, I wouldn't say rare because we're seeing it happen, more frequently, but it is infrequent. And so at least 3 of those 4 cases, we know there were 2 justices that voted to grant cert. Simply because a justice doesn't join that dissent doesn't mean that other justices, that there wasn't a 3rd justice who was willing to hear the case as well, which meant that there would only need to be 1 other justice. During this time period, with these denials, Justice Kennedy was on the court. And so there's speculation. So again, when I say in thinking about these cases, I think about it through the lens of what does it say about the institution of the Supreme Court. And of course, a lot of this is speculation on my part, but it's fun kind of thinking about it, that, Justice Kennedy certainly could have potentially been a 4th justice if we think we had Justice Thomas, Justice Scalia, Justice Alito might very well have been a 3rd vote, possibly Justice Kennedy. And then thinking about what Justice Roberts may have been or may have done with respect to denial of cert. And was there a specific reason why they did not want to take those cases, notwithstanding the fact that you had some justices that were really concerned about how the lower courts were deciding these Second Amendment cases. And then we get this case where cert was granted in 2019, and of course we've got Justice Kavanaugh replacing Justice Kennedy. And so it's certainly easy to speculate that maybe this case was, cert was granted in this case because of Justice Kavanaugh joining the court. So to the extent Justice Kennedy felt uncomfortable with maybe some of those prior cases, maybe Justice Kavanaugh did feel comfortable. That's one way in trying to understand maybe why it is that the court decided to take this particular case. I think another way in which you can look at this case is that this case is different from some of those prior cases. And this case, in terms of the facts of the case, it's closer to the Heller case in that there's a challenge to a regulation that affects one's ability to have a gun within their home or to effectively have a gun within their home. And so that's different than, say, a ban on assault weapons or a ban on magazines or a 10-day waiting period. So even if Justice Kennedy were still on the bench at the time that this cert petition was filed with the court, I'm not convinced that the court wouldn't have taken cert anyway, right? Because Justice Kennedy seemed to be particularly concerned about the inability in the Heller case of an individual not being able to have a gun in their home. And what was being challenged in this case in New York was the inability of one who had a premises license to transport that gun that they, legally had to another home within the state of New York, even though not within the city, or to a firing range where they could practice and become proficient with the gun. And so I'm not sure that Justice Kennedy wouldn't have a problem with this New York law. I'm also not convinced that Chief Justice Roberts wouldn't have had a problem with this New York law. So it's, so I don't think the simple answer is that the court took this case because Justice Kavanaugh is on the court. I certainly think it made it more likely, but because of the nature of the law that was being challenged in this case, I think it's, a fair guess that maybe the court would have taken it anyway. So one of the things that I wanted to talk about was, so the mootness, and as Jake noted, the court granted cert in, I believe it was January 2019. The law or the regulation, the New York regulation, was repealed in like July of 2019. And then you had the state of New York actually passing a law saying that this regulation could not be reinstated. And the majority of the arguments were focusing on this mootness issue. And again, when I'm thinking about the court and I'm trying to predict, which I just do for fun, it's like if I go to Vegas and I'm playing, the crap table or I'm playing 21, I don't do it to try and, make money. It's just an exercise. And so to the extent I make any sort of predictions, take it with a grain of salt. And this is just all for fun. But so in thinking about mootness and thinking about how the court might decide the case, in listening to the arguments, if I had to predict, I would say that the court would probably deny or the court would dismiss the case as being mooted. But I don't think it would be a unanimous decision. I think it would be a split decision. And, 5-4, maybe 6-3. I think from the argument, it felt to me as though Justice Alito and Justice Gorsuch were really concerned about the government attempting to moot the case. Justice Thomas, who says very little at oral arguments, but he says a lot in writing, and we know that he is seriously concerned about how the lower courts have been deciding these Second Amendment cases. He has been eager to have an opportunity for the court to address the appropriate standard. I can't imagine that he would say in this case that it is mooted and lose the opportunity for the court to address the merits of the case. So I think that's probably a firm 3. I could see Justice Kavanaugh potentially joining the justices in reaching a conclusion that the case is moot. I would be very surprised if Chief Justice Roberts sided with the case not being moot. And I think one of the reasons why is because of his role as Chief Justice. And he clerked for then Associate Justice Rehnquist. And I think he understood Justice Rehnquist's role when he became chief. And so also when Justice Roberts was clerking, that was during the time period when Chief Justice Berger, who was not a particularly good administrator on the court, so he kind of saw, how not to be a chief. He was able to observe Chief Justice Rehnquist, and even though there were many justices who disagreed with him, Chief Justice Rehnquist, ideologically, pretty much all of the justices said that he was a fair administrator, a fair chief, and was concerned about the institution of the court. And Chief Justice Roberts has said on a number of occasions that there's a particular role that the Chief Justice plays, and that's to make sure that the institution of the court is protected. And he has also expressed, most recently with this report on the court, about the court being seen as too political. And I think the court, particularly in light of the fact that the law that was being challenged in this case no longer exists, for the court to reach a conclusion that it is not moot. Let me know if I'm running out of time as well.
You're good.
If the court reaches a conclusion that this case is not moot, it feels incredibly political. And I think he doesn't want to put the institution in that position. And I think we saw that when Chief Justice Roberts sided with the liberals and upheld the Affordable Care Act. And I think he was concerned about the court appearing political. So I would be really surprised. And so I think you've got the four liberals plus Chief Justice Roberts, so that, it's kind of, I'm not going to say foregone conclusion because I'm always surprised by the court, but I would put money on it, right, that the court would reach a conclusion that the case is moot. However, I do think one of the more interesting considerations is what's going to happen with the dissent, because I would be surprised if there's not a dissent also on the issue of mootness. But what I'm most concerned to see is if those justices that are in the dissent write an opinion on that focuses on the proper standard in deciding Second Amendment cases. And one of the things that we talk about in my Supreme Court seminar is the power of dissent. And so as the court has become more divided, I think the court has always been political. And even though Chief Justice Roberts and others say they don't want the court to be political, it has always been political. It will always continue to be political. I don't think it has been as partisan, though, because one of the reasons why you've got, the short list of judges, potential Supreme Court justices that's given to Republican presidents is because those conservatives want to make sure that you don't have a Kennedy again, that you don't have a Warren again, that you don't have a Souter again. And so as individuals are being selected based on their strong conservative views, their strong liberal views, the court has become, I think, much more partisan. And so when we're thinking about the dissent on the issue of how the Second Amendment is to be decided, the dissent can play a couple of roles. And so the power of dissents, which are becoming more and more frequent, justices use dissents to speak to larger audiences beyond the parties of the particular case, beyond the lawyers in the case, beyond, the legal academy, or, right? So speaking to legislators. A perfect example of that was Justice Ginsburg in her dissent in the Lilly Ledbetter case. And so that was the gender pay discrimination case. And the Supreme Court had reached a conclusion reversing the almost $4 million she got in back pay in her Title VII claim against Goodyear, that she failed to file her Title VII claim within a timely manner, notwithstanding the fact that she had no knowledge that she was not being paid the same amount as her male counterparts. Justice Ginsburg wrote a strong dissent and basically called for Congress to pass legislation, which Congress did. The Lilly Ledbetter Act was the first piece of legislation that was signed into law by President Obama after he assumed office. And so she utilized that dissent to make this really strong point and to speak to, beyond just, the parties in that particular case. Dissents are also used to lay a foundation and to anticipate what might happen in the future with respect to the court. And so if we have a dissent in this case, And it speaks to the proper test that should be applied in Second Amendment cases. Even if it's in a dissent, it could possibly become the majority view down the line. And so an example of that is when we had Justice O'Connor in the Akron Center for Reproductive Health. She wrote a dissent in 1983. In that dissent, she said she had a problem with the trimester approach in the Roe decision, and she said the proper standard should be the undue burden standard, right? She articulated that first in a dissent. And then in the Casey decision, when she wrote that joint opinion with Justice Kennedy and Justice Souter, what was the standard? It was the undue burden, right? And so writing dissents allows the justices to kind of lay the foundation for what ultimately might be the actual result of the court. The final thing that I'll say, how much time?
You have 5 minutes.
Okay, 5 minutes. All right. So the final thing that I'll say about the reason why I think it might be important for Justice Thomas and those other justices to write a dissent in this case is the only articulation from a Supreme Court justice on the appropriate standard on how to decide Second Amendment cases comes from Justice Breyer in the dissent in the Heller decision. And a lot of lower courts have been kind of modeling that framework that Justice Breyer laid out. And so there's no competing other Supreme Court justice articulation of it. And so that would at least allow them to have a counterpoint to what Justice Breyer. And again, even though it's in a dissent, it still provides some basis, some argument that can be utilized by judges at the lower court, attorneys, academics who are writing on this issue that really want to push for a much more stringent review of Second Amendment cases. And let's see, last thing that I'll say is, in terms of what might we see going forward, even if the court were to deny this case or to dismiss the case as being moot, the court is going to have to wrestle with this issue as to what the appropriate standard is, sooner rather than later. And it's because I think the court consistently has 4 justices who are going to vote to hear the cases. And so while the court had opportunities prior to this particular case, because there were not 4, I think with Justice Kavanaugh joining the bench, that there is, a solid 4 at this point. And so the court is going to have to address this issue. And so I'll stop there and then answer any questions at the appropriate time.
Thank you.
Thank you. Again, thank you for having me as well. I appreciate the invitation and the opportunity to speak to you. Some of you may know that the Heller case held that the Second Amendment protects the individual right to keep and bear arms for the purpose of self-defense and other lawful activities. The court said it's not a collective right. It's not a right that is connected only to service in the militia, as the dissent suggested. But Heller left 2 big unanswered questions. One is the extent to which government can regulate firearms in public, not the home. Heller dealt with a District of Columbia law that required either the locked storage or disassembly of a firearm in the home. It had no occasion to comment in that case under the facts what the appropriate standard would be outside the home. So the second question is, how should lower courts decide Second Amendment cases going forward? In other words, what is the framework for decisions? Now, Justice Scalia, writing for the majority in Heller, did say that did reject an interest balancing approach, if that's sort of the traditional levels of scrutiny. Some have argued that it is, some have argued that it isn't, but I think that was in response to Justice Breyer's proposed approach in his dissent. And so with these 2 questions about the scope of the Second Amendment outside the home and the framework of decision-making going forward, the court just went silent for many years, with the exception of McDonald, which applied the Heller decision to the states, and the Caetano case, which was a relatively minor case holding that a stun gun is a protected arm under the Second Amendment. There have been no other Second Amendment decisions from the Supreme Court. So with the NYSERPA case, at first glance, this case seemed to be maybe a good vehicle for giving further guidance, answering these questions. What's the scope of the Second Amendment outside the home, and what is the framework for decision-making in lower courts? North Carolina, as Jake said, prohibited those holding a premises license to possess a firearm at home from transporting that firearm anywhere except to one of the 7 shooting ranges in the city of New York, and to a gunsmith for repair if they transported the gun either to the shooting range inside the city or to the gunsmith. It had to be locked and unloaded. There was no transport to any other places where the firearm could be lawfully possessed, not a second home, not to a firearm range outside the city. So this fairly restrictive transport ban, and I use the word ban delicately, in light of Professor Blocher's article, wonderful article on that, and I think if you haven't read that, I would encourage you to do so. But the transport ban seemed obviously an overreach, obviously unconstitutional, but it was upheld by the district court and by the Second Circuit, both seeming to treat the Second Amendment as much more of a homebound right. And I think both of these decisions, particularly at the Second Circuit, sort of reinforced the idea that some have suggested that the lower courts were really not taking the Second Amendment and Heller very seriously. So it seemed like a good vehicle for correcting the lower approaches to the Second Amendment, deciding whether it's the text, history, and tradition test that should be used, as Heller seemed to use as a model, not as Heller didn't specifically prescribe that test, or the two-step approach that's developed in the lower courts since Heller, which asks first, does this activity implicate the Second Amendment? And second, if it does, what level of scrutiny should apply, whether it's intermediate or strict scrutiny? And so some were a little surprised when the court took the case. It's not one of the big cases involving, say, for example, a May issue permitting system or an assault weapon ban. But immediately after the court took the case, the city of New York, and as well as the state of New York, tried to moot the case, tried to make it go away by passing a law that the state passed a law that said that you can transport a firearm to a second home, shooting range, or competition, or any other place where you're licensed to possess a firearm, but that transport has to be directly to and from. Apparently no diversions on your trip there. And the state statute preempted local laws like the one in New York. Now, the question of whether this is moot obviously was triggered by the New York State's law. Now, the petitioners in the case say, well, it's not moot because there's still a question about future enforcement of the ban, and this sort of invokes the voluntary cessation doctrine. I don't know if any of you have discussed that in some of your classes. I loved what the Beckett Fund, who filed an amicus brief in NYSERPA on behalf of neither party, said, if angels were to govern men, the doctrine of voluntary cessation would be unnecessary. It's a great brief on the whole question of voluntary cessation. So that was one point the petitioner said of why it's not moot. They also argued that it would not prohibit the city from taking past conduct into account in licensing decisions under the New York scheme. You have to be of good moral character to have a firearms license, and if at some point you had violated the ban, even if you had been arrested and cleared of violating the ban, that could go to denying a permit in the future. And then there was also the question about to what extent does the Second Amendment right would that be consistent with this requirement that this continuous and uninterrupted transport? The government weighed in on the mootness doctrine and says, well, there's still a question about money damages, even though the petitioners had not specifically asked for money damages. They did have that sort of boilerplate that's at the end of every complaint, any other relief that's proper there. So when it came to the oral argument, the questioning was dominated by those on the side of the court that dissented or would have dissented in the Heller case. Most of the questions were about the mootness doctrine and its application in this particular case. Now, I think that the mootness doctrine is something that does need clarification. I'm not sure that this case is a good vehicle for clarifying the mootness doctrine. Maybe you get to the question of whether voluntary cessation applies to a government entity, which in this case, New York City argued that it doesn't. And that might be some point of clarification. And maybe perhaps when there seems to be an obviously collusive attempt to avoid SCOTUS review, in this case, as happened once the court took cert, the state of New York, which is not known for its friendly gun approach to gun laws, is moved to try to moot this case because it was afraid, as many gun control advocates were, that the court would come out and make a decision that was strongly supportive of Heller and clear up some of the things that Heller left undecided. So I don't know. Professor Dawson talked about perhaps maybe Chief Justice Roberts not wanting to appear political here. I think maybe an argument could be made on the other side of that, where the Chief Justice might not want to appear allowing a very political move by the state of New York and the city of New York to attempt to moot this case stand. It's hard to say whether the court is going to decide this case solely on the question of mootness. I think if it does, you're probably going to have Chief Justice Roberts, as Professor Dawson suggested, voting with the more liberal-leaning side of the court on that question. Interestingly, there was no dig that was granted dismissal of cert as improvidently granted, which could have come out just a few weeks after oral argument if they had decided the case is moot. Also, there has not been cert granted in any other of the pending Second Amendment cases. You can't read too much into that, but given the time that has passed since the oral argument in this case, I think the longer the time passes and the court holds in abeyance its decisions on these other cases, perhaps the stronger the expectation is that the court is really going to decide this case on the merits and not simply on the mootness doctrine. Now, if the court does decide that NYSERPA should be dismissed as moot, then there are several other pending Second Amendment cases. The Second Thoughts website has a great list of them. I would encourage you to go to that to see what they are. They're an amalgam of cases dealing with a variety of Second Amendment issues. I think the two most likely types of cases that the court might hear would be either one of the may-carry cases or perhaps even consolidating all of them. There are currently 5 may-carry cases pending before the Supreme Court on cert petitions now. The may-carry cases involve challenges to laws that condition the issuance of a public carry permit on some special need for having a firearm in public, some special danger, some reason, such as you may be, closing your restaurant at 2 a.m. in the night and taking the deposits to the bank at that point. So the effect of these types of may issue or may carry laws is to deny the vast majority of people who want to carry in public, who want to get a license to carry a firearm in public, to deny them the right to do so. Now, there is a circuit split on these cases. A number of cases have gone the way of upholding these laws. The D.C. Circuit in the Wren case a couple of years ago struck down D.C.'s law on that. So there is a split. Probably the most likely case that the court would take on this would be the Rogers case, which has been it was distributed for conference back in May of 2019. It has to do with New Jersey's May issue public carry regime, and so that could be a case in which the court certainly would have the ability to answer these questions: to what extent does the Second Amendment apply in public, and how should lower courts decide these cases? What's the appropriate framework for decision? There are also 2 assault weapon ban cases pending before the Supreme Court. 5 circuits to date have upheld assault weapon bans. There is no circuit split on these cases. I think they also could provide a good vehicle for the court answering the 2 questions. The most likely case there would be the Werman case from the First Circuit. But again, as I said, there's no circuit split on these assault weapon ban cases. There are other cases dealing with bump stocks, micro stamping, felon in possession. I doubt that the court would see those cases as good vehicles for deciding what left undecided after Heller. Now, what does need to be clarified? Well, certainly the decisional framework. Is the proper framework one of these text, history, tradition type of approaches where you look at the text? Certainly the argument that's made in the NYSERPA case and other cases when the Second Amendment says to keep and bear arms, that bear arms has a direct reference to carry outside the home. History, tradition, are there historical analogs to these laws that have been upheld in the past that have been treated as not encroaching upon the Second Amendment rights? Or should it be the 2-step approach that almost every lower court has taken since Heller of deciding first whether the Second Amendment does apply? Is the Second Amendment implicated by the conduct that is prohibited? And if so, what level of scrutiny should be applied? I think if the court does embrace the 2-step approach, it still has to clarify when strict scrutiny should be applied. The lower courts have said, well, strict scrutiny should be applied when the law impinges upon the core of the Second Amendment protections, and then they go back and define that very narrowly to essentially ensure that the Second Amendment remains a homebound right. And in almost all of these cases, in the circuit cases since the Heller case, the courts have applied intermediate scrutiny, and I think that is also another question. What constitutes proper intermediate scrutiny in these cases? Should there be some actual evidence supporting the laws as opposed to shoddy reasoning or inaccurate data? And I would add not uncritical acceptance of pro-gun control advocate statements. What about narrow tailoring? Should there be some showing that the objective achieved is to be achieved more effectively through regulation. In other words, that the regulation really, there's some basis for believing the regulation will be effective, and should there be some consideration of substantially less burdensome alternatives. So these are things that I think can be clarified, certainly in one of these may issue cases, but I think they also can be clarified in an assault weapons ban case. I would love to see the court take an assault weapon bans case. That's the area that I've been writing on I've got one article out on that, and I'm working on another on that. I think an assault weapon ban case would also provide the Supreme Court with an opportunity to explain what arms are protected under the Second Amendment, to define this common use test that seems to have emerged from Heller, and also to describe what types of weapons are considered dangerous and unusual and therefore not protected under the Second Amendment. So I think there are assault weapons ban cases can give the court an opportunity to decide probably more questions that need to be resolved under the Second Amendment since Heller. Although since there is no circuit split there, I would probably I would predict that type of a case probably would not be taken in favor instead of one of the may issue cases. So I think that's all I've got.
All right. Well, thank you to both of you. That was very enlightening. I just have a couple questions, and I'll open it up to the audience if you all have any, but I could have questions all day. So first one to you, Professor Dawson. So it's striking when we look back at Heller and we think only 5 of the current justices were on the court when Heller was decided, and it was only a decade ago, and yet the court has changed so substantially. And one thing you said was maybe this case would have been granted if Justice Kennedy was here, and so just interested in your thoughts on the fact that this cert grant came 6 months after Justice Kavanaugh came on board. Does that tell us anything, or is this such an outlier that we don't know yet if this is going to be a one-off or if this is like a new indication of the court willing to get into Second Amendment cases?
So I certainly think that when we think about strategic litigation, and so when you have what you believe is a favorable court, and you've got a case that you can find that can make its way up to the court, then you bring it in. There's no doubt in my mind that this was, perfect timing, Justice Kavanaugh joining the court, particularly in light of his dissent in the Heller 2 case. And he dissented from the D.C. Circuit's decision upholding registration requirements in D.C., and this was following, the striking of the D.C. law banning handguns. And he chastised and disagreed with the majority in terms of the test that was used to analyze the regulation, the registration regulation. And so, without a doubt, those that are bringing litigation know that Justice Kavanaugh would be favorable to having the court review this issue, particularly in light of the fact that the D.C. Circuit's majority was consistent with how other circuit courts were deciding these Second Amendment cases. But notwithstanding that, I think because of the facts of this particular case, which are different from the May carry and different from the assault weapons ban, that it was factually a little closer to the Heller scenario, that I think that cert probably would have been sought anyway, and there's a good chance that it would have been accepted by the court with Kennedy.
Yeah, I think that makes a lot of sense. So kind of building off that, Professor Wallace, there, as you say, one of the things left open by Heller was the proper framework. What did you make of the discussion in the NYSERPA oral arguments, brief as it was, if anything, about what the methodology should be going forward? There's some hint from Justice Sotomayor being skeptical that this is a test that we should apply in this sphere, and some other justices seeming to latch onto it. Did you make anything of that discussion?
Well, I think certainly the petitioners in NYSERPA wanted the court to adopt the text, history, tradition test that was espoused by Justice Kavanaugh in his Heller 2 dissent. Now, whether they were aiming at his vote, I think they probably already had his vote, but nevertheless, I think if the court adopts the text history tradition test, it's going to have to be very careful how it explains that test. It's a little more ambiguous or amorphous. I mean, if what you're doing is looking at the text and then looking to see whether there are any historical analogs to the law that is being challenged, whether it fits into the three types of presumptively constitutional laws that Heller identified. I think you're going to have a little more specificity, if you will, as to how that test works and is to be applied. Perhaps more simple would be for the court to clarify the two-part test, and specifically when it comes to the interest balancing, the levels of scrutiny. I think that there has been wide criticism from those on the more pro-Second Amendment side that the lower courts have really reduced the heightened scrutiny at the intermediate level to something akin to a rational basis type of scrutiny with extreme deference to the legislative bodies. And I think the court could, even if it doesn't adopt that test, I think the court could clarify that there needs to be some, if you're going to apply intermediate scrutiny, it needs to have some teeth to it.
Yeah, that makes a lot of sense too. All right, let me open it up. If there are any questions out there, if they're not, no worries, but if there are any questions, I just want to make sure we get to them before at the end. Yeah.
When you hear about something like an assault rifle ban, I know I don't have a lot of information about the different types of guns, but you do hear that there's misinformation going around about what certain types of guns are. But you said we haven't yet seen a circuit split on the decision about that. Do you have any context on how people's opinions on whether or not what an assault rifle is plays into the fact that there hasn't been a split yet?
Yes, I do. I actually wrote an article on that last year that had to do with challenging a number of the factual assertions that are made in these circuit court decisions about how AR-15s, which is really the aim, although AK-type rifles and other type of rifles are included in the assault weapon ban. The AR-15 is the most popular rifle in America, and there's a lot of disinformation that makes it into these court decisions. For example, the Fourth Circuit in the Colby case said that AR-15s can fire 300 to 500 rounds a minute. Well, that means that you're going to have to be able to, since AR-15s only fire one bullet for each trigger pull, you're going to have to pull the trigger, 7 or 8 times in a single second to reach that kind of rate of fire. And even if you just focus on the semi-automatic rate of fire, there again is a lot of disinformation. Colby was trying to make the AR-15 look like it was a machine gun in its rate of fire. But even if you focus on the semi-automatic rate and look at what the military specifies as the maximum rate of fire, it would be around 45 rounds per minute, not the 300 to 500. So there's a lot of disinformation. Bottom line is that the rate of fire with an AR-15, since it has a semi-automatic firing system, is no different than the rate of fire of semi-automatic pistols, which Heller called the sort of quintessential home defense weapon. And what I'm writing now on is the question of assault weapon lethality, and that is that courts have upheld these bans primarily because of the perception that these firearms are exceptionally lethal, far beyond any other types of firearms, and that's just not true. So I think that, yes, there's a lot of disinformation. There's disinformation that creeps into these court opinions because what they do is they rely on evidence that's provided by ban advocates. The D.C. assault weapons ban, the D.C. Council relied on testimony from Brian Siebel, who was with the Brady Center, And the Court of Appeals picked up that testimony and credited it, even though without any kind of determination of whether it's actually factual.
Thanks for the question. Anyone else? Yeah.
So I know there's a big rural-urban divide as far as owning guns and being in favor of owning guns. A lot of like Keller and the recent New York law came out of cities. So I'm wondering if there's any acknowledgement of that, and if there's any room in the Second Amendment to make a distinction between rural and urban ownership.
Oh, okay.
Amendment expert.
I don't think the constitutionality of like an assault weapon ban or a make carry thing turns upon rural or urban. I think the question would be whether the law is narrowly tailored to fit the state's interest in public safety. One of the things about Second Amendment cases, and those of you that have studied the tiers of scrutiny will know that you have to have the state either has to have an important or significant or compelling interest. And in this case, that's pretty well solved. It's always public safety. Okay, so that's always either an important, significant, or even compelling interest. So the real question is in the narrow tailoring of whether these laws are sufficiently narrowly tailored to not be, too over-inclusive. And perhaps the narrow tailoring question might make more sense in urban areas where you have the potential of, for example, over-penetration of rounds in home defense situations. And but I think you can argue that the self-defense calculus also goes up in urban areas as well, because there are very many people who want a firearm for self-defense in high crime areas in urban areas. So I think it sort of cuts both ways in that, but I don't think that it's that kind of a distinction is going to be decisive in a constitutional case.
And the only thing I would add, I think, Professor Miller, don't you have an article where you kind of talk about the difference between okay, all right. Well, I know you have some wonderful articles too, so. Yes. And so, that's a perfect article where, there's the expansion on that issue. So I just wanted to mention that.
Yeah, and just to draw that out a little more, right? So historically, gun regulations have been more intrusive in cities and urban areas than they have been in rural or areas that are not urban. And so there is this argument that you see sometimes that if you're going to do a historical test, then maybe the historical test should be calibrated to what the historical regulations were. We do this in other areas of constitutional law, right? Obscenity. We look at local standards and what community standards are. So, it's not out of the realm of possibility to think that there might be a different standard that could be applied in certain types of settings versus other types of settings. Any other questions? Yeah.
The way that I read the new law is that I think you mentioned it. You have to go directly to a place out of state. So say,
Out of the city.
Exactly. And the way I think about it is you go out and you go to a shooting range or a trap and ski range, then you go and eat dinner afterwards, and hypothetically you'd be violating the law. Isn't that an argument kind of against the mootness thing? And then also in regards to the mootness, I guess, the Roberts worry about the political nature of the case, I guess, in general, but it seems like there's a good amount of politics on both sides and possibly more politics on the other side, just because of the amicus brief that was filed by Schumer and Gillibrand, as well as the fact that they changed the law specifically so that the issue would then be moot. So I guess I'd just like to hear more about that, and then whether or not you think there is an argument that it's not moot.
Well, Justice Alito asked the question during oral argument: What if you're going out to a second home and you stop by and see your grandmother? Would that count? And I think the answer was not terribly conclusive from New York's side. So that potentially could be an issue with the mootness in this case. To what extent, even under the revised law, does that overreach from a Second Amendment standpoint?
And what I would say about it is, and the attorney for the city kind of made this point, which is the city of New York repealing the law and the state of New York enacting a law saying that, these types of laws cannot be promulgated again, these regulations can't be promulgated again, is not a bad thing. And so it's not a question of was there a deliberate effort to try to moot the case. It's based on the repeal of that regulation and the enactment of the legislation. Is there currently a case in controversy based on the complaint that was filed? So even if it was deliberate, Article 3 requires that there be a case in controversy. So, having the state of New York actually passing a law ensuring that the city is not able to promulgate a regulation like that again means it's pretty clear that, the city is not going to be able to do what it did previously. So, yes, it was a deliberate attempt to moot the case, but, that happens and that's okay. Voluntary cessation isn't automatically a situation where it's going to be an exception to the mootness doctrine, right? If you can demonstrate that whatever behavior has been ceased will not happen again, then the case is mooted. And the justification for doing it doesn't defeat the requirement that the Constitution require that there be Article 3, that Article 3 is satisfied.
Yes, Professor Miller.
There's briefing by Schumer, but there's also briefing by, Republicans in the House. But, there's gamesmanship in terms of this particular case, right? This particular case is not about shall issue, may issue, any of those kind of regulations. It's not about, there's a whole separate licensing regime that's not even at issue in New York City on that point. So one of the questions is, well, why would you bring a cert on an outlier regulation to talk about public carry when there's this line of cases that actually directly address the issue about what is the scope or permissible regulation of public carry. And so I'm kind of interested in how you think about, well, why is it that this case gets granted cert, NYSERPA gets granted cert, as opposed to all the ones that are directly addressing the either may issue or shall issue or what kind of guns you can have or whatever. Why is it this case gets granted cert?
Well, I was as surprised as you were, I think, because I don't necessarily see this as a good vehicle for resolving some of the unanswered questions left after Heller. You could say that the public aspect of the Second Amendment is implicated by the transport ban. This is not just about, nobody's prohibiting anybody from having a gun in the home. You can, as long as you buy one in one home, and as long as you buy a different one for a second home, it's just you can't transport it. You can't go out in public with it. Also, can you transport it to other places where you could engage in lawful activities, like shooting competitions, those kind of things. So I agree with you. I think I was a little surprised by this. Well, I guess a lot surprised. I thought it was now with Kavanaugh on the court that they might take up one of these, what I would call bigger cases in that regard.
And this also seems to me like it's a baby step, and so it allows the court to be able to deal with a factual scenario that I think could easily have been troubling to Roberts, right? And so reaching a conclusion that you're prohibited from a gun that you legally possess in one home, that you cannot transport it to another home within New York. I think that would have been an easy call for the court to strike that down. And so it felt to me like it was, let's kind of ease our way into this, as opposed to, especially during this election year, right, jumping straight into an issue with respect to maybe assault weapons or must carry. So that's the way and again, all speculation on my part, but yeah, that's my explanation.
I think you very well may be right about that. This was maybe aimed at Chief Justice Roberts and his incrementalism in that regard. But he really hasn't tipped his hand so much in Second Amendment cases before. But yeah, I don't know.
All right, well, please join me in thanking our panelists. Thank you.
Thank
Thank you, thank you. Justin's gonna stop by and say hi. He had a committee meeting at lunch today, but he wants to say hi to both of you. And I need to, I'm gonna go grab something for you.
So the last